Can you imagine losing everything from doing a simple lease option? Well, you don't have to imagine anymore. You're going to get to hear it live.
I have come here to chew bubblegum and kick ass, and I'm all out of bubblegum.
This is the Virtual Real Estate Investor Podcast with Vincent Palisi. Buckle your seatbelt and prepare to learn how to legally make six figures investing in real estate with no money, no credit check, and nothing but a computer and internet connection. Learn how you too can begin generating buyers and sellers for free today, and why you're only 2 calls away from making a $10,000 or more payday while never leaving the comfort of your home. And now, your host, the virtual real estate investor, Vincent Palisi.
All right, I want to welcome you to episode 006 of the Virtual Real Estate Investor Podcast. In this episode, we are going to cover a live webinar that we did. It was actually a live paid webinar that we did on a topic that many of you need to be educated on, and that is this, lease options. They are sold by guru after guru as the panacea of the easiest way to make money in real estate. Unfortunately, most people don't know how to do them correctly. They don't know all of the pitfalls that are involved in these types of agreements. They seem very simple, but let me tell you, they're not. But as always, you don't have to take my word for it. We've got a panel of guests in this webinar. This was actually a hot seat that we did where I tore apart a real estate attorney's contracts. This attorney is actually the real estate attorney that Joe McCall uses. And we went through step by step, document by document, clause by clause, all of the, I don't even know how to say it, landmines that were involved in these contracts if they ever ended up with somebody that knew what the law was. You're going to get to hear all that live. You'll also get to hear from Bill Walston, who's a CPA and professional real estate investor. You'll get his take on it as far as what his impression is, what the tax laws are, what Dodd-Frank laws are. And then to top things off, you're going to get to hear from Scott Moyes, who is also a real estate investor. He's based out of Salt Lake City, Utah. And Scott ended up losing everything from doing what was perceived to be an improperly structured lease option deal.
Hey, what's up, investors? John Lee Dumas here, founder and host of Entrepreneur on Fire, awarded Best of iTunes 2013, and you're listening to the Virtual Real Estate Investor Podcast with my man, Vincent Palisi. Prepare to ignite.
You think I'm talking about breaking the law?
No, I'm just trying to figure out how far you want to bend.
As far as you can without breaking it.
Okay, welcome everyone to our very first edition of the Hot Seat with the Virtual Real Estate Investor. Today's guest is Angelo Russo, real estate attorney and owner of Avalon Escrow. Our panelists today include Bill Walston, and you have to forgive me, I'm going hoarse now that we're about to do this. So if I sound a little froggy, that's why. Bill Walston is a CPA and professional real estate investor, and we also have Scott Moyes, who is also a professional real estate investor, and they both have experience and information here related to the topic at hand. What we're going to be discussing today is lease options and the standard way that they are being peddled by a lot of the guru crowd that's out there, which is wholly incorrect and will get many of you in a tremendous amount of trouble because a lot of these contracts are structured improperly. And the problem that you have, unfortunately, is that and you guys probably know this better than I do, but what it sort of seems like to me is that a lot of these guys take a course, they find success with something, and then they begin teaching it. And unfortunately, that is not the path to being an expert or having all the knowledge that's associated with it. So there are many fallacies that are associated with contract law. If you've never litigated some of these things or been dragged into court, you understand exactly what it is that can happen. So what we want to do is I'm going to take you through pardon me, I want to take you through a contract prepared by an attorney, that's Angelo. And as an investor, I'm going to pick this apart based on what I know, and then I'll open it up for Angelo to comment, and then for Bill to come in, share his thoughts and experience, and then Scott as well, because he's got Scott's actually been prosecuted for a lot of what we're about to discuss. So if you have any questions, please type them into the chat box so that we can answer. There should be a chat box on your right-hand side, I believe. Or maybe there's a question, I think the questions box here on the right that you can ask questions, and you can also chat, and we will get this thing going. All right. So just to give you some background here, I've done tons of lease options over the years. I've done them for clients. I've done them for myself personally on homes that I had acquired. They can be a very useful tool. The problem is that 99.9% of the time, they are used incorrectly, and they are very, very bad deals for both buyer and seller, or if we use the correct terminology, landlord and tenant, and optionee and optionor. Okay, so I'm going to show you exactly why that is, why I got away from them back in 2008. Most people don't understand all the mechanics and how they actually work. And we'll kind of then we'll then go through the contracts so you can understand what some of the issues are associated with them. But one of the most glaring issues in the standard lease option agreement is what is called the equitable interest argument. And what happens in most lease option contracts is unknowingly equitable interest is created. You also have the creation 9 times out of 10 of what is called a de facto or disguised sale. And that comes down to what is the intent of the agreement initially, as well as what is the verbiage that's utilized in the contract and how are certain things applied. And we'll go through all these line by line so you can understand exactly how this works. Now, what happens is this, and just to give you an example, if I were to be the tenant or the optionee on the standard contract that is used and sold out there in a lot of these courses, okay, what I could do is get into the property, immediately stop paying, and when they made the effort for the dispossessory action to evict me, bring forth the equitable interest argument, okay? And at that point, the judge cannot evict me. He has to take it through the landlord then would have to take it through what's called the judicial foreclosure process. All right, and you're going to see that based on the way these contracts, you guys can see exactly what I'm talking about line by line. Got them up here somewhere. There. Okay. All right. So if we go through, this is the standard residential lease I've used. And before I even get into this with Angelo, let me tell you guys this. I personally have used a document almost identical to this one on many deals that I have done as well. Okay. So when I tell you it's the norm that's out there, I've actually done a lot of this stuff myself. I don't do it anymore for all the reasons that you're about to find out, but let me kind of go through this. So can everybody see the lease? What I've gone through here is I've gone through and I've marked up the lease with comments so you can see exactly what I'm talking about, and then we'll address these line by line. But basically, in the very beginning, we get into lessor is not obligated to accept any rent payment that is late more than 2 days after its due date, even if such payment is accompanied by an amount equal to the late charge. I'm not aware of any state that is legal for a couple of different reasons. Number one, most states, there is a period of time, and I'm not a lawyer, I'm not an attorney for any state. I certainly don't know all landlord-tenant law in all 50 states, but of all the states I've ever done business in, I'm not aware of any state that could be the case, or that we would have the ability to evict without remedy, meaning generally in most states, the remedy for a default is to hit the tenant with what's called a 3-day letter to pay or quit. Sometimes it's a 5-day letter, depending on what state you're in. And at that point, they have the ability to remedy the defaulted payment and continue on with their lease as originally laid out in the contract. Okay. So I don't know, Angelo, is that an Ohio thing? Is that legal there?
Normally it's 3 days, so that's why the late fee isn't added until the 3rd.
Okay.
Also, the 3-day notice when you're giving to someone isn't 3 days notice to cure the default. It's 3 days to remove yourself from the properties to prevent the foreclosure from being filed against you, but it still doesn't stop your obligation on the lease. So the 3-day notice is not a notice to cure the default. It's a 3-day notice saying that if you leave the property voluntarily, then I will not file a forcible eviction action.
Right. And that I agree with. In Georgia, they use what's called a 3-day letter to pay or quit, and it's either pay and cure the default or leave and we won't proceed with the dispossessory action. So that's why I'm asking.
In Ohio, you do not have to.
Okay, and that's why I'm asking
you do not have to keep someone the action.
Okay, so you're telling me that
Ohio,
if somebody's 2 days late, you can evict?
3 days.
3 days.
So on the third day, if they haven't paid, I can give them a 3-day notice, and I don't have to take the rent anymore if I don't want to.
Okay.
Now, judge is probably going to give you a hard time if you're doing that, but you are legally allowed to do that.
So when he shows up in the dispossessory action, the judge is not going to ask him for payment or issue the dispossessory warrant?
No, they're basically going to go through a list of questions. I don't have them in front of me now, but they basically say, they ask the landlord, did the person pay the rent? No. Did you give them a 3-day notice? Yes. When did you give it to them? On this date. How do you know that they received it? Have you collected any money since that date? And then they'll ask the tenant, are all these things true? You're gone.
Got it. Okay. Yeah, like I said, that may be an Ohio thing. I'm not familiar with Ohio state landlord-tenant law. I think part of the issue that I had with it in reading through it was that, and it may be accurate, like I said, it may be accurate for your state, but these things are being utilized by people all over the United States that have bought into the wholesaling lease options course. Okay. So I can tell you for a fact that that's not legal in most states.
Well, you guys are lucky if you can do it in 3 days.
I've never heard of that before.
Yeah, Tennessee requires a 30-day notice.
Wow.
A 30-day notice, and then if they do the same thing within 6 months, then you only have to give a 14-day notice. But if you're assaulted by the tenant, you can give them a 3-day notice. That's the only time. If they've damaged your property or assaulted you or something like that, you can give a 3-day notice. But other than that, I mean, typically our notice is 30 days.
Wow.
How long does it take you to get a court date?
Much longer than 30 days, unfortunately. But we actually do have to show that we've given a 30-day notice. And they've passed in Tennessee what they call the Uniform Residential Landlord and Tenant Act, and it's kind of crazy. It's very, very tenant friendly.
Yeah, as an example, I've got investment properties in New Jersey, and they have till 5 days past the first before you can even consider a payment late. So again, this is definitely a state by state specific issue.
Very much so.
Like I indicated, if it is legal in Ohio, this document is correct as far as that's concerned. But my issue with it is it's being peddled and used in all 50 states where that is not necessarily the case. So let me move on down here.
When we get a new client that signs up for Avalon, what we'll do is we'll find an attorney in that state, and we'll ask them to review our documents, and they make changes to them for that particular state. Now, I don't know every other state, and that's why we ask for that to happen. So we actually take on the burden of the cost of hiring someone in each state when we get someone in, like a new contract. So if someone came to me from, South Carolina and they said, we'd like you to do a lease option over there, since I don't know my documents are valid there, we'll contact someone in South Carolina. We'll send them our documents, pay them to go over them, make any changes to make them valid in their state, and then those are the ones that we use.
Well, that's a good way to do it.
And you know what, Vincent, I think that's really great. The problem that I have with a lot of these courses is people buy a course and they take that contract right out of the course and disregard any state requirements. I think at a minimum we ought to be telling people, say, you need to have these reviewed by your attorney.
I can totally concur. And I know when we've done stuff on the owner finance side in Colorado, as an example, they have some very state-specific things that have to be done on a contract for deed. We're notifying the I forget what they call it, but it's the property tax magistrate, I think is what they call it, and of the change in who's going to be responsible for tax payments and that kind of thing. And if you don't do that, you don't have a valid contract at that point. So very, very important if you guys are out there, kind of flying by the seat of your pants with contracts from some course. They're not universal in every state, and they will absolutely hang you out to dry. So it's imperative to understand what it is that you're doing, and certainly, contact a real estate attorney or get a state-specific contract depending on where you're getting your contracts from. So, all right, if we go down through this, the very next thing we have in here, which we're going through.
Hey, Vincent.
Yeah.
Let me just, if you mind, let me address something. You bring up a really good point about getting in front of these judges, and you never know what they're going to do or say, as we'll find out later when we talk about what happened to me. But you never know what they're going to do or say, and most of them, to be honest with you, a lot of them don't even know the law, and that's a big problem for the tenant, not necessarily the landlord, because unless the tenant actually brings an attorney to a court of eviction, which is very rare, and actually knows how to make their claim of equity, they'll all just be evicted. Of course, as you just heard, in some jurisdictions they're more tenant friendly.
Right.
But unless they're able to make the proper claim, usually by an attorney, not by themselves, they're never going to get. And that's the argument that I get all the time. You know me, I make a big deal out of that. And it very rarely happens as it did to me. And that's the reason, is because they don't have the proper representation, nor can they afford it. And even if they had the proper representation, it would cost a lot for an attorney to forestall their eviction and force a foreclosure. So that's why most tenants, and I'll say 99% of them, are able to be evicted from lease options, is because not only they don't know, they don't have an attorney, and the judge doesn't know either, unless a good attorney brings it up.
Yeah, no, I agree with that. And I think what most people don't understand is that the judges typically are sitting there waiting for both sides to bring them the supporting case law that substantiates.
Well, and this is the argument. This is the argument that I get from gurus. I've even gotten it from you and even from Bill, is that, well, this stuff just never happened. And I wouldn't say never, but you're absolutely right. It's the same issue when we start talking about due on sale violations too. Does it happen? Very rarely. Can it? Absolutely. It's a violation of a contract, and if it's argued correctly, then as what happened in my case, I'm screwed.
Yeah, I agree. Totally agree. All right, let me kind of go through this so we can get moving along here. I didn't understand, Angelo, I didn't understand this clause, because you've got basically two clauses that discuss assignments, subletting, et cetera, in here, but we can skip past that because it's not really what I was getting into here. The big one here, as far as I'm concerned, is the maintenance and repair aspect. Again, and this maybe it's an Ohio thing. Pardon me. I am not aware of any state anywhere that allows deferral of all maintenance and all repairs to a tenant, because that is a landlord's and or owner's responsibility. And when we start getting into the equitable interest argument and layering clauses in contracts based on the intent for the de facto or disguised sale, and I'll let Bill address this as well. The IRS, who is the ruling authority in the United States, their definition basically is, if it walks like a duck and it talks like a duck, it's a duck. And so many of these lease option agreements are strictly nothing other than a de facto or disguised sale, where the initial intent is a sale. That's the purpose of the agreement. And when you layer it with, and I've done the same thing, so I'm not pointing fingers, but when you layer it with the maintenance and repair onto
I lost you, Vince.
Yeah, we're still here.
I can hear you guys.
Yeah, we don't know where Vincent went. Maybe he lost his voice altogether.
Oh, sorry.
There you are.
I had to cough. I didn't want to cough on the microphone, so forgive me. What I was saying was that the maintenance and repair issue here, that what happens when you start layering clauses in contracts based on the intent, and that's what the judges are going to be looking for, and that's what the IRS is going to be looking for, is what is the intent of the agreement. And when you take a maintenance and repair clause and make all maintenance and repairs a responsibility of a tenant, okay, so that's what this is. I'm not aware, again, and maybe it's an Ohio thing, but I'm not aware of any state that legally allows that. Does it happen? All day, every day. I've done it a ton of times myself. Is it legal based on landlord-tenant law? That I would question, because I know it's not in Georgia. I know it's not in Florida. Maybe it is in Ohio. I don't know. But
it is not in Ohio. but let me explain why it's there.
Okay.
Almost everything that you do when you're an investor or a wholesaler or a lease option is psychological in respect. So what we do is, and this is why I warn people not to just take forms and use them because they don't understand behind them. And that's one of the things that we had discussed, where someone might take my forms and they bring them back to me and they don't understand how to use them. I explained to all of the owners when they sign these documents, listen, if you go to court on this clause, you will lose, okay? I tell them straight out, this is not something that you're not allowed to put the burden on the tenant for these kinds of repairs. The reason why we put it on there is we want the tenant to feel like he's owning the property so that he's going to be responsible for everything. But I let them know, listen, you need to make a decision, a business decision. What is it that you want? Some people put in here anything less than 500, the tenant's responsible for. Anything more than 500, the landlord is, in order to try and get a halfway point, like you said, for the de facto sale, but still psychologically so that they know for any of the minor things they're taking care of. Most of the landlords that I deal with, they want the tenant to feel like they're responsible for everything and not to bother them. Now, like I said, I tell them up front, if you go to court, you will lose on this clause. We have it in there as a psychological barrier from the tenant coming back. And it comes back on a lot of these things on these documents, and I think it's exactly what Scott said, that if there's a default in these arrangements, it's generally the tenant who fails to make the payments. And if the tenant fails to make the payments and you go to court, you want to try and protect the landlord or the owner, because the tenant, if he doesn't have any money to make the payments, doesn't have money to hire an attorney, and so it's going to be a lot easier to get it done. If you're protecting the tenant too much, now all of a sudden, if there's a default in some way, the landlord owns the house. More than likely, they have a few grand to pay an attorney. So that's why we gear things more towards the landlord from a psychological standpoint, and that's why this clause is in there in that way. But I agree with you 100% that this will not be enforceable in Ohio.
Yeah,
Does that make sense?
Yeah, perfect sense. Like I said, I've used the exact same clause many times for all the reasons that you just cited. The challenge is, and as Scott gets into his story, this is a big bone of contention for the equitable interest argument and the de facto sale, where a tenant can force the judicial foreclosure process if they're savvy. I've seen people get strung out literally for 18 months with a tenant in place on a deal like this, where the tenant knew exactly what the law was and what to do. And it's one of the reasons why we have in all of our contracts that they waive trial by jury, because in Georgia, as an example, believe it or not, on an eviction, they can get a trial by jury, and it takes 12 months to get that set up because it's never done, if that makes any sense. And meanwhile, the entire time they're not paying. And so we've got that. We have them waive affirmative defenses. We have them, I take them through, it's a spring-loaded bear trap to make sure that we're protected. But, the concern for me, from a seller's perspective or from a landlord's perspective, who is ultimately our client that we're going to have a relationship with, through the duration of this contract, even though you're in and out technically because of an assignment or depending on how they're structured. But if it's an assignment, then you still are married to you're still married to both people. I hate to say it. You're in and out technically legally, but you're the first person that's going to get a call in most cases when something goes upside down. So move on. That to me was the big thing, because like I said, the equitable interest thing and forcing the foreclosure is something that you want to avoid at all costs if possible. You got on here, and you had like these two clauses back to back. I wasn't really understanding because they're kind of redundant, but you have an inspection. It says lessor and his agents shall have the right at all reasonable times during the term of this lease and any renewal thereof to enter the demised premises for the purpose of inspecting the premises and all, and all building and improvements thereon. I'm not, again, maybe it's an Ohio thing. I'm not aware of any state where I don't have to give at least 24 and sometimes 48 hours written notice before I come in, unless it's an emergency and there's, the house is on fire, there's water coming out of the front door or something like that. Is that an Ohio deal?
No, you're required to give at least 24 hours notice, but we just put it on there in case someone has an issue. We had one now, to give you an example, the person signed the lease option, they went into the house, and they didn't like the carpeting and they ripped it out. And the landlord went berserk because it was newer carpeting. They're like, what are they doing to my place? I want to come in and see it. The person was there. They could have refused them entry, but they said, okay, hey, this allows me to come in. I saw you tearing this thing out. I'm worried about my property. It's not an emergency. There's not, a water leak or anything else. But it's just in there so that they can make the argument if they want to try and go in. But again, yeah, it's 24 hours written notice as a requirement, whether it's in the lease or not. I've had some people tell me, well, I want to take that out. I said, well, you can take it out, but the statute says that you got 24. If they give you written 24 hours notice, you got to let them in anyway.
Exactly. Okay. And this next one is something that kind of caught me off guard in the document. I'm not sure why this is in here, honestly, unless it's a lease for an apartment, which doesn't make sense. It says, acknowledges common areas in the building in which the apartment is located. I didn't understand why
it's just a matter of whether sometimes if there's an apartment or if there's a townhouse, and that probably should be taken out if it's just a regular home. But a lot of townhomes might have common areas, things like that.
No, and I agree with that. I think the point I'm trying to make to the people that are listening here is that these boilerplate contracts that you're getting from these guys that you're buying these courses from, they contain clauses like that nobody's reading or addressing. And you've got to take the time and craft your contract specific to each situation and make sure when you're using them over and over again that you actually read through them and don't make errors that don't apply. Okay, so then we get down here to the assignment and cancellation, and it says lessor acknowledges and agrees that original lessee, okay, this is a previously undefined party who I don't know who this is at this point, has the right to assign its interest in this arrangement to a third party for a fee without the consent of lessor. I understand what you're doing here. You're saying the lessee has the right to assign, but we've identified an original lessee as opposed to whom. That I didn't understand.
It should be defined, but original lessee would be the person who actually signed this agreement the first time.
And
there's a lot of times we've had.
Would that be the investor?
That would be the investor.
The investor on this document, yes.
Right. Okay.
But I've also had deals where it's not an investor who takes it, and they just want to have the right to assign it later on if it doesn't meet their needs.
Gotcha. Okay. Yeah.
But these two clauses were added specifically for investors.
Yeah, no, it makes sense. I understood what the intent was. All right. Here's probably the biggest one. And I know Bill's going to have a field day with this one. When you have on your terms, pardon me, and we start getting into rent credits. Credits are a big, big, big no-no. I used to do them. You used to be able to get away, back in 2007, we could get away with 100% rent credits for the first 12 months, and the bank would finance that and give them credit for it in the purchase agreement. All that changed and has continued to change since then. And if I'm not mistaken, I don't think they're crediting anything other than payments above and beyond the actual rent. But there's new loan products coming out all the time, so I don't know if anybody's actually doing these and closing these like this. Maybe they can address that.
What they did in recent years, Vincent, was they would look at what fair market rent was, and anything above fair market rent they would allow.
Yeah, exactly. Yeah,
to the down payment. Yeah.
Yep. That's what I was trying to say, I believe.
Yeah.
But it's that and anything paid over and above.
Yes.
And guys, for the people out there that are familiar with the mortgage industry, I used to be a broker years ago. We used to have what was called lease option refinance program. And you're exactly right, guys. They would take into consideration, previous to this mortgage mess, as much as 50 to 100% of the rent being credited, depending on the property value and so on. And as long as they could show it was an actual cash transaction. And then, of course, whatever their option deposit was or whatever they agreed to or gave them up front. And they used to be fairly simple. We still kind of do that today. Even FHA will allow some of that.
Gotcha. Okay. From my perspective, again, playing devil's advocate, playing the tenant that's going to fight this in court, the rent credit application coming against the purchase price is, if I were to do a lease option personally, as an investor, you never, in my opinion anyway, and maybe Bill can address this, but you never ever mention the other document. They're two standalone agreements that have nothing to do with each other. If you want to stay out of hot water.
That's why we separate.
Right.
And that's why we separated them as well.
Pardon me?
That's the reason why we kept them separate. A lot of people had single-page documents, and this was more because of the confusion. And I tried to point it out to the investors. The way that I like to do it is if you had a rent credit of, let's say, $200 a month, you would put that onto the option agreement that says it's $200 for the option agreement continuing each month, and $800 would be towards the lease. But it got too confusing for people on how that worked, that they're like, just put it as a rent credit. We understand the risks, and we'll move forward.
Yeah, from my perspective, though, now that you're applying principal balance reduction, which is what you're doing, principal balance reduction is for a sale.
Exactly.
So we understand the intent here is not truly a lease option. It really is to create a sale. But and I'll let Bill get into that here in a second. All right. So moving along, we go to the option to purchase real estate. Forgive me, Angelo. I don't know. This is a big pet peeve of mine. Is when we have titles that do not belong in contracts. It drives me insane. On an option agreement, from my understanding, and I'm not an attorney, it's option E and option or. I don't know where purchaser and seller come in, because there is no purchaser because he has an option to purchase. He's not buying. He's not agreeing to buy. He has an option to do that. Seller I could get along with because he is in fact the seller, but he's not really the seller for the term of this agreement. But beyond that, if we move on down, you have purchase price. Generally, I would have that defined as an option strike price, not as a purchase price. Purchase shall be entitled to possession of the property at signing of this agreement and accompanying lease. And here we go again. We're referencing the other document, which I would never do, because now, based on the way that judges respond to this stuff, we have a sale here. We do not have a lease agreement and an option agreement. We actually have a disguised sale. So I don't ever reference either of the two documents together, because if you're going to do that, you might as well just have one document. There's really no reason not to.
Vincent, what that does when you're talking about relating to the documents, in my opinion, and I ask our local members here and investors all the time, do they know the difference between a lease purchase and a lease option? Of course, to make things really short here, is a lease purchase is an obligation, not an option, and a lease option is an option, not an obligation. By referencing the other document, what you've done is you've taken the lease option and created a lease purchase. But as we'll talk about later, the IRS ruled against that clear back in 1917, and they consider any lease with an option the same as a lease purchase.
Did not know that.
As long as the leasee is also the optionee, or the optionee is also the leasee, they consider that a lease purchase. Or that's where we get the term a delayed or disguised sale, is what the IRS determines that.
Gotcha.
A lot of people ask, well, what does the IRS have to do with it? Well, if there's a sale of anything, right, what do they have to do with it? So it's all about tax.
Yeah, their hands out. Okay. And now we go back down once again to rent credits. We've kind of beat that mule already, but in my opinion, based on my experience, based on how the judges are going to rule, you've got equitable interest at that point, because they're getting credit against the principal balance of the property upon executing or exercising the option. We've got the rent credit thing here again.
Yeah, it's considered a down payment.
And that's the option fee, and then this. So what he's done here, and this document here is not Angelo's document, but this is.
Can we go back one?
Yeah, which one?
Go back to the option agreement. The automatic termination clause that you said won't fly.
Mm-hmm. Oh, sorry. Did I blow past that? Where did it go?
I agree with you that it probably won't, but when you go to sell it to somebody else, you want to be able to give something to the title company to clear it off. And even though by law it might not work, it's enough to get through the underwriters in order for you to sell it to somebody else.
Run that by me one more time.
The automatic termination clause in the option, if you can show that you evicted someone and now you're going to sell the property to somebody else, and you need a title company to do the work, they're going to say, hey, this option was recorded. When you can show them that this had the automatic termination language in there, as well as a copy of the eviction to show they're no longer in possession, they'll clear it so that you're able to sell it to somebody else from that cloud on title.
Okay, so what you're referring to, if I'm understanding you correctly, is that this has nothing to do with the dispossessory action and everything to do with assuming that the dispossessory action went through because he didn't appear or didn't know what to argue. And you've got an option or a memorandum of option recorded in the courthouse that you now have a cloud on title that you're trying to remove. Is that what you're saying?
Correct.
Okay. All right. We're arguing two different sides of this. What I was saying is if I brought this up in court with the judge as the tenant, I'm not aware of any scenario where they're going to revoke the rights of the optionee because of a defaulted lease, which has nothing technically to do with it, unless we're joining the documents and creating the equitable interest once again with the lease option. So that was my point, and I understand what you're saying. In our agreements when we did the lease option deal, we had a strict prohibition against any memorandums being recorded for that exact purpose. So it's smart that you've got that in there. Okay, this other document, pardon me. Now, this is not Angelo's document, so he doesn't have to comment on this at all, but it is being packaged in with his documents and sold, and I'm assuming being utilized by people. And once again, this was actually, if this copyright is accurate, it's by Claude Diamond. And on one form here, you have a residential lease and you have an option to purchase all on one document. Option consideration. I don't know if this just isn't filled in or what, if with the rent credit, maybe he's doing 0 rent credits. And if that's the case, I'm not even sure why they would even list it on there. But again, you've enjoined the documents here. You've given constructive notice of enjoining the documents here, which I wouldn't do, and I wouldn't want to have this brought up in court if I was the investor personally, or the landlord or seller of the property, strictly because of that. Okay, now we get over to the assignment, pardon me. And so I assume what they're doing here is the investor is signing as the tenant and lessee on the original document with an ability and right to assign. He then assigns that for a fee, which would technically be an option fee, an assignment fee, not an option fee, because the option fee would be paid in his option up front. And he would be assigning that contract then to the end tenant and optionee. And this document then references option payments, which I didn't understand because it seems like that the option would have already been paid and transpired at that point because it was $10 in the other agreement. And then it didn't address the assignment fee. Pardon me?
There are other agreements when the option fee isn't paid in full up front, and let's say the seller or the optionor is asking for $100 a month on top of the lease payments. So it isn't the fact that the $10 is the sole payment each time.
Gotcha. No, I understand. And we're dealing in generalizations here in many cases because we're using a sample document, not something that's actually specifically been created for a transaction. But all right, let's get through that. Now, what I did this morning was, and this is, we're going to lead into the experience that Bill has as a CPA, and then the experience that Scott went through was, quite frankly, I could not remember what the IRS regulation was, the actual number, so I could pull it up for you guys for equitable interest in de facto and disguised sale. So I did a Google search real quick, and I went through about, 6 or 7 websites, and I finally came along one that had the information that I was looking for. And I have to tell you, I was reading this morning on the couch, having my coffee, and I started chuckling when I finally got down to the bottom and I saw who the author of the article was. It was Bill. So, and I have to tell you, before we even scheduled this, I didn't have any knowledge that he had any knowledge of any of this. He just he tends to be a very good moderator and brings a level head to any of these webinars that we do in a different perspective. So, but yeah, it kind of worked out perfectly. He has all the knowledge, and I'm going to let him kind of roll into and explain what the IRS regulation is and his understanding of it.
You talking about the revenue rolling 55,540?
Yes, sir.
Okay. Yeah, that's basically the disguised sale, where they say whether an agreement, whether it's a lease or an unconditional sales contract or whatever, it's evidenced by the provisions of the agreement read in the light of the facts and circumstances existing at the time the agreement was executed, basically. So it gets back to that idea of intent is one of the major things, but they're going to look at a lot of the circumstances surrounding the transaction itself to see whether the intent was to be a sale or whether it was actually a true lease. And one of the things they look at is whether a portion of the rental payments are specifically applied to equity in the property. And Vincent, that's what you were talking about when you were saying that we were going to run into an equitable interest problem, and when we had payments that were being applied to a principal balance, or even payments being applied to a down payment. So it says if portions of the rental payments are specifically applied to equity in the property and think rent credits, it's more indicative of a sale rather than a true lease. Another thing, and this was actually more of like car leases and things like that, but we can apply it equally to real properties. If it's title to the property will transfer to the leasee upon payment of the rental payments, meaning that the payments over time are actually equal to the purchase price. That doesn't usually happen in a lease option deal, but I've actually seen that before. So it can happen, and that's one of the things they look at. In other words, you get to the end of the lease term, and I'm thinking some of these people who used to have 10-year leases, right? And the payments have been equal to the entire purchase price. If the amount paid in rental payments is an excessively large proportion of the total sum to be applied to secure the transfer of the property is another indicative item of a sale. If there is a situation where the property is transferred under a purchase price that is nominal in relation to the value of the property. So that was those old types of deals. Again, it was more in equipment rentals and things like that, but they applied the same principles. It used to be where you paid over a period of time, like 5 years, and then you paid $1 at the end of the lease term, and it was yours. It was more like a rent-to-own type deal. So these are things that they are going to look at. One of the major ones I almost forgot was the lease requires the leasee or the buyer to make substantial improvements to the property. That's directly out of the revenue ruling. So that's why we were getting back to the transfer. Angelo, even if it's just a psychological thing, I think that may be why Vincent brought it up. Because if you're trying to transfer all the substantial repairs and maintenance over to the buyer, then it's going to be more indicative of a sale and not of a true lease and option.
Yeah, let me jump in for a second here, real quick,
Sure.
Bill. So this will make sense because the contracts that we use now are in compliance with the IRS's installment sales contract guidelines, and
right.
For a contract for deed to be classified under IRS ruling as a bona fide sale, where the buyer can then legally deduct the monthly payment that they're making, or the portion thereof that's interest and taxes, they have to do and assume all of the liability and responsibility of a homeowner. In
Correct.
This case, they have to take over maintenance and repairs,
exactly,
insurance, everything. And so that to me is when I saw that, that really stands out as, okay, well, this is their definition of what a sale is, and these are the requirements that we have to have for them to get the tax deduction, then it certainly would apply. And if we're doing the same exact thing in a lease, how is that not construed as
not a sale? Right. And so that's why we say you can't transfer the substantial repairs and maintenance. So, what we were telling our folks now to look at is to make sure that you don't have rents that are way over fair market value. And some of the people who were teaching lease option deals would say, oh, you rent if you're doing a lease option, right? So they would bump the market rent up several $100s and say it's okay because it's going to apply to the purchase price. Well, you can't do that if you want to make sure that you're not going to look like a disguised sale, because that's one of the first things they'll look for, is to whether the rent that you're charging is at fair market value. Another thing I say is no rent credits. One thing, and Angelo, you might be able to speak on this. One thing that is allowed is seller concession. So I've had a few people who would say, okay, if we can't do rent credits, can we just tie into the option that we can give a certain amount as a seller concession for successfully completing the option requirements? And here in Tennessee, I've got a few attorneys saying, yes, you can do that. So we're doing away with the rent credits and using seller concession in that respect. Another thing is make sure that your option price is at or near fair market value, and don't try to pass on your repairs and maintenance. I think that getting to, saying leaky faucets and toilets and stuff like that would probably be okay, but fixing a furnace and repairing a roof probably would not be.
I think it would be interesting if you go to court and they're going to say that this is a sale or a disguised sale because of the fact that you have this clause in there that the tenant is responsible for all of the repairs. If you make the argument that says, by law, I can't pass those things on, which means this clause is invalid, so I didn't actually transfer those obligations to the tenant, so you can't use that argument.
Yeah, that would be interesting. My thing on that, though, is, whether it's enforceable or not, and maybe this is more from a tax standpoint than it is from a legal standpoint, but whether it's enforceable or not, I can guarantee you the Internal Revenue Service is going to look at that contract and say, you attempted to do it, whether you were actually legally able to do it or not. And so it's still more indicative of a sale. A court may not rule the same way. So because I am looking at the IRS ramifications of this, but one of the things that led me to look at this anyway was because of Dodd-Frank, because some people are missing the entire point of the fact that if your lease option can be reclassified as a sale, as an installment sale, then I would venture to say that Dodd-Frank rules and regs are going to apply, and you may have bigger problem than just not being able to evict your tenant.
Yeah, I was actually going to lead into that because basically what happens here is you start layering with these clauses that create this domino effect of it being deemed and ruled by a judge in a court as a sale that then forces the judicial foreclosure process, which you don't have in a lease, obviously. And so now you have the argument that a tenant, and again, playing devil's advocate, if it were me, knowing what I know, and I wanted to play the game here against Angelo as the attorney, that's exactly what I would do. I would string him all the way through that and then go file a complaint with whoever the governing czar is of Dodd-Frank for the state and say, we have a sale, blah, blah, blah. And what they're doing now, if you guys haven't read about this, is they can actually, they've deemed in Dodd-Frank that they can actually come in, take your property as a seller and landlord and transfer the ownership to the tenant or the buyer in that case. Okay, if you violated some of these provisions. So you got to be really careful with what you're doing because they're not playing games.
And not only that, I mean, one of the major clauses of Dodd-Frank, if it was imposed as a sale, and like Angelo had said, most tenants would not know this, but if you ever did find one in the know, it would only take one, as Scott could probably tell you, it only takes one to really screw you, because that one tenant could come back and say, okay, this is a sale, therefore this is seller financing, therefore Dodd-Frank applies, and most likely the landlord seller would not have taken into consideration the tenant's ability to repay, which is the big thing with Dodd-Frank. So they would owe back all 3 years or up to 3 years of the monies that had been paid in. And they would have to follow the rules and regs for an eviction or a foreclosure. And under Dodd-Frank, you've got 120 days before you can even file for a foreclosure. So
I am so very lucky. I'm so very lucky that wasn't in effect when that happened to me.
Scott, go ahead.
Because like Scott said, I mean, it only takes one, right? Only takes one.
Yeah. Like an IRS audit, it only takes one.
That's right.
Sure.
All right. Well, Scott, that's a perfect lead in for you. Why don't you tell everybody who you are, what your experience is? I've got your story story up here.
And anybody, we're going to do this real quick. Obviously, I can probably stretch it out for a long time, but I'm not going to do that. If anybody that wants a copy of that story, all they have to do is email me. But the bottom line is, guys, is that, just like what we're talking about here, I was led to believe that that these contracts and even some of the people that have been mentioned here in this webinar are the people, let's put it this way, it was two attorneys' contracts that I used that got me in trouble, and yet neither one of these gentlemen would help me or support me or defend their own documents. And they were the attorneys that supposedly drafted their own documents. So, but the bottom line is I found out real quick that, when I had a tenant that didn't pay or couldn't pay, that the state, because of certain reasons, stepped in and helped defend this young lady that I was trying to evict, that I actually was trying to help because her husband left her. Long story, won't go into it. But when we ended up getting into court, they brought in an attorney to help her that, as a law student, fourth year, sixth year law student, whatever, decided who was an excellent researcher, found, and I'm out in Utah, but she found that this obscure, and I won't say obscure, it was obscure to me, but not to Arizona. She found law in Arizona, case law in Arizona, and legislation that was used against me in my state. And I get asked all the time, well, how in the world can they use Arizona law against you in Utah? Well, it's called case precedent. It happens all the time across the country. And it only makes sense. And what they got me on, I'll tell you these things. They got me on, and I'll say they get me, just lack of a better term. But what I got prosecuted on, or not necessarily prosecuted, but what I got sued on, is there's 5 basic rules that the legislators in Arizona created that would determine if your transaction is a delayed or disguised or a sale. And what's really interesting is years before this ever happened to me, I actually knew and did business with and had done business with the guy that eventually became the judge, the guy that actually helped draft the legislation in Arizona that nailed me in Utah. And so also in my story, I have actually a transcript of my personal conversation with Judge Pierce, Lester Pierce in Arizona, and you can read that too. But the bottom line is, here's the 5 things, and if you think about this, guys, it only makes sense. And the Arizona legislation, by the way, guys, is the underpinning of all the lease option or anti-lease option or predatory lease option law that was passed back in September of 2009 for Texas. There's one in Cincinnati that they actually call the anti-predatory lease option law. And of course, Ohio, sticks their nose into things all the time and has specific legislation that they just posted, matter of fact, on Facebook for all investors to know and to scare the crap out of. It has no teeth, by the way. But here's these 5 things. And now think about this. All the lease option courses or all the lease option gurus or all the seminars you've ever been to, you think about these 5 things and what they told you about these. Number 1, here's the things you can't do. Now, they're not criminal. It's just if you violate any one of these things, and actually there's 6, but if you violate any one of these things, your transaction can and will be deemed a sale. Now, being deemed a sale is exactly what Vincent's been talking about, is that it brings up that claim of equitable interest, which is what happened to me. So number 1 is this, and I know these sound ridiculous. You cannot predetermine a purchase price. Because if you name a purchase price, isn't that a sale? Isn't that what you're agreeing to? That's what they're saying. Number 2, you cannot collect more than 1.5 times the normal monthly payment up front as an option deposit. Number 3, you can't credit any part of an option deposit or any part of the rent towards a future purchase. We've kind of already gone over that, right? To do any maintenance. Now, they didn't define any, but I agree with what Bill was saying, is that, heck, if you make them fix their leaky toilet, that's one thing, but the roof's another, right? So they're saying you can't, in other words, they can't, as Vincent said earlier, they can't act like a duck and walk like a duck, or they're a duck. Okay. And what's interesting is number 5 is based on the ruling in 1917. It's McClellan versus something I can't remember right now. It's in the story that the IRS ruled that a lease option is not a lease with option at all. It's a delayed or disguised sale. It doesn't matter if you have one document that's a lease purchase or called a lease purchase, and it doesn't matter if you separate the two documents. It doesn't even matter if you refer them to each other or not, as Vincent was talking about earlier. As long as the leasee is the optionee, and the optionee is also the leasee, you've got a delayed or disguised sale in the eyes of the law. And if you do any one of those 5 things, not just in Arizona, and if a smart attorney somewhere else can get a hold of this and find case precedent, they can use it against you. And if they make a great argument, as what happened to me, we ended up going out and settling out in the hallway, and I lost everything because of one person that I tried to help. Now, there's a 6th one. It's an IRS thing, and previous to 1982, it was really a much bigger deal. The IRS says that any lease of longer than 3 years, even if it doesn't include an option to purchase, can be deemed a sale in their eyes. Now, Bill, you may know more about that. I think that's changed a little bit since.
Yeah.
But previous to 1982, of course, that's in St. Germain. That's what they could rule, and they did quite often to collect taxes. So those are the 5 things that nailed me, guys, in my state, based on another state's laws. And I know that's what they used again as an underpinning in Texas and Ohio. I think some areas in Florida. And in other words, guys, if it hurts when you do that, don't do that, right? That's what this webinar is all about. And if there's any kind of potential danger involved, we're trying to educate you to look for those potential risks and liabilities in these transactions. And not just lease options. Because of Dodd-Frank, it's really brought all this into these other type of methods and documentation and so on. So I know Bill's done some great webinars with Susan Lassiter and others on the Dodd-Frank issue, and he's pretty well versed on that. So that's kind of my story. I'm the, you guys know me, I'm the land trust guy. Tennessee treats them a little bit different, as you know, Bill. But yep. I discovered for myself that if and ways to eliminate those 5 things using the land trust and occupancy agreement. And maybe that's another webinar in and of itself. But anyway, there's my story, and I'm sticking to it.
All right. I'm going to see if Lisa, it looks like you're still on here. Do you mind coming on and explaining what happened to you last year? I'm going to unmute you. Lisa, can you hear me?
Yep, I can hear you.
Okay.
And by the way, Vincent and Lisa knows this, I think. The Lease Options Sucks Facebook page was created just because of Lisa's story.
Yeah. Lisa, start at the beginning. Tell them how you got involved, what happened, et cetera.
Okay. Well, first of all, I want to thank you and Scott. You guys helped me a lot with when I was going through that. So I really want to thank you for your help.
My pleasure.
Basically, what happened is this tenant decided that they didn't want to buy anymore, and they just let the place run down, and the city came in and evicted them themselves. And there were supposed to be things that were supposed to be taken care of. They weren't doing it because the city official told them that even though it was in the contract, it wasn't their responsibility. It was the landlord's. So that's where it started. And then, so they got sued. The sellers got sued. And I wasn't even a part of it at that time, but I went to court with them to help them. And the court commissioner flipped through the papers, and he shook his head and huffed because it was like a confusing mess to him. And he said, he said, well, why are you suing these guys? You should be suing Lisa Barton. She's the one that has your money. And the buyers looked like they had, like the cat that swallowed the canary. They just had a big smirk on their face, and they're like, oh, okay. And that's how it started. So I already knew when I went back in there, I had the fight of my life because he already had me guilty. So, and I had to go back in front of him. So that's where it started.
And so they...
You didn't try and get him recused?
Yeah, that's what I would have done too. But
what was that?
Did you try and get him recused for giving legal advice?
I knew it was wrong, but I didn't know exactly what to do about it.
Yeah, part of the problem that she had at that point was, hold on. Part of the problem that she had at that point, Angelo, was that she couldn't get any attorney to represent her, even if she was willing to, fork over thousands of dollars up front. That's how she ended up getting on Facebook and, saying, hey, this is what's going on. But yeah, it was a mess. And, when I took a look at the contracts that she had, and I don't know if she wants to tell where she got them from, but that's up to her. They were a mangled mess of incoherency and basically left only one leg to stand on because it did create the de facto in disguise sale. It was an absolute, if it had been me as the tenant, she wouldn't be so thankful right now. I can tell you that just based on how bad these things were put together. And the fact that I guess the other people, I don't know if they had an attorney or not, but they didn't know what they were doing to prosecute it the right way. But at any rate, they had the entire thing going on. No attorney would take it for her. The one little hinge was this one sentence that was in the agreement that was very poorly written, but it was what I told her to kind of hinge everything on, which was essentially it was a waiver of liability and hold harmless. And it was a mess. I know she was going through a ton of stress for weeks as this thing was going on. But go ahead, Lisa, and tell them, just walk them through it. What happened?
Well, I was on it, and I'll say it was Joe McCall's website, and so I put a post on there, and it just got a lot of attention. People were asking questions, and I'm begging for answers, and then Scott and John Houston, they came and told me to talk to Vincent, so I did, and I never didn't know who you were, so, but I was desperate, and so you helped me. Everybody was helping me, except the person that sold me the course, and then finally I get a message from him on Facebook. He just says, "Lisa, call me." So, and he sent a link, so I had to go to his calendar. And his only available spot was a week from then, and that was the week of court. I'm like, oh my God, this was just crazy. So I put it in there. I was supposed to have 15 minutes, but he was late, got on there, gave me 5 minutes, and just kept saying, well, what is it? What's the problem? What is it? He kept interrupting me and saying, the contracts are good. They speak for themselves. And I said, that's not the point. I went to the commissioner. He didn't like the contract. And he's already got me guilty. And he goes, Lisa, don't lose sleep. You're going to be fine. Don't lose any sleep over this. And that was it. He had to go because he had another person. I'm like, okay, that didn't help me at all. So I had to focus on the contracts. I looked up Wisconsin law, and I had to focus on it. I had to figure out the points in the contract that were going to help me. And one of them was because I used to be a realtor. And I know that anytime you change anything, you have them sign it or initial it and date it. So in the bold letters where it said that they would lose their option fee, I had them initial it. And that really helped a lot because I pointed that out in court to show the judge that they knew that they were going to lose their fee. So that helped a lot. For the attorney that you were saying, Vincent, we tried calling a bunch of attorneys, and one of them said that Wisconsin is pro-consumer, and then the other one we actually visited with, and he looked at the contract and he goes, well, this isn't Wisconsin contracts. And I'm like, well, not all contracts can be Wisconsin. There's all kinds of contracts, so it just takes two parties to agree, sign, and money to exchange hands. And he said, well, true, but you're not going to win. And So I put up an argument with him because we really wanted an attorney to represent us in Wisconsin. So because I knew this commissioner was, like I said, he already had no guilty. So he wouldn't take the case. And so as we were leaving, the last thing he said to us, he goes, "Well, I'm sorry you guys are going through this, but you're going to lose." And I'm like, "Great." It's just, I had no place to turn. I just was fighting for this because the contracts were confusing to them. It was confusing to me. I was looking for somebody to help me explain to me exactly how I could understand, because I had to understand them before I could fight, the court system with them.
Yeah,
so.
let me stop you right there for a second. And therein lies the problem. Okay. That is the problem with these courses. Okay. They're providing contracts, they're dispensing legal advice without being an attorney. And then you end up as the student, the investor, you end up getting sued, and you don't even understand the contract yourself because it's never been explained.
Mm-hmm.
And this is one of the reasons. This is not to pat myself on the back, but this is one of the reasons why I handle all the contracts. Contracts go out in my company name for any people that are working with me, so that if anything does come up, it's not coming back on them. It's coming directly back on me at that point, or my company at that point, because I do know how to handle it, and it acts as a barrier and a shield against exactly what you went through. Okay. Now that doesn't mean they can't attach and try to enjoin you in the suit as well. But you would not even be a named party on any agreement with a prospective buyer or tenant optionee, or depending on what type of transaction we're doing. You as the student wouldn't even be on there because you're not qualified in most cases. You haven't been trained on contract law. You haven't been, and you guys, I'm assuming, I don't know if this is the case or not, but I assume you prepared the contract. Is that right? I mean, you were given the documents and they're like, you filled in the blanks or forms or whatever.
Are you talking about me? Yes.
Yeah.
Yes, I did.
Okay.
I filled them in, but I went on the website, where they had all the samples and everything, and I followed it, and whether I knew what I was doing, I did exactly what they did. So I put it in there, and I read it to try to understand. Like I said, I was a realtor, so I kind of understand contracts, but It was even confusing for me. So what I ended up doing, because I didn't want it to be confusing in court, I did a flow chart. And Bill Rafter's the one, he suggested do a flow chart. So I'm like, okay. So I took that idea and I went through the contracts and pieced it together exactly how it all happened. And so I had big boxes, just like like they were a kindergartner I was talking to. I wanted to make sure I had big boxes, showed exactly how it happened. And it turned out that he was impressed by by how I had it all laid out, and he ruled in my favor. So I was extremely happy, except then they have a right to go in front of the judge. So they filed again to have a trial. So now this was a whole different ballgame because, I went in front of the court commissioner, but then I had to go in front of the judge. So, and so we did it. I mean, piece by piece, step by step, and a lot of worrying. Yeah, but we did it. So, and I also the sellers, they were totally lost. They didn't know anything about what to do about any of it. They were looking to me. So I represented both of us. I went in and I handled it, the whole thing for them and for me. So, I was really, honestly, I was really shocked that I won. I was really shocked, but I did do my homework and I did take advice that you guys gave me, and I applied it, and I came out of it. So I just don't want to ever get in that position again. Never.
What would you recommend to people to not be in that position?
Honestly, I just don't do it. I would never do it. But, if there's a way that's a better way to do it, then yeah, but that's why I look to you, because for me, I don't ever want to do that. I don't want to do lease options because I am a landlord and I do know a lot of the details that, courts look for between the tenant-landlord relationships. And there was a lot of those things in that contract that was kind of like, I don't know. I was questioning myself. I was like, I don't know if this would really fly in this court system. So I've been in it before.
Sure.
And I don't know if it would ever fly. And there's a lot of those things like you guys were just talking about, like the repairs, who's going to take care of repairs and stuff. That just doesn't fly in the court system. If they're a tenant, the tenant is not responsible for any of that. It's for and that is up to the judge. If the judge is going to say, yeah, it's in the contract, we're going to go by it. But out here, I doubt that they would go by it.
Angelo, let me ask you a question. Is there some reason that you can tell me or explain to me why, given all that we've just covered here, and a lot of it you already knew about, obviously, as you said, some of these things are in there for psychological reasons and all that. Why not just go directly with a sale, like using an owner finance contract or Scott's title holding trust or something like that?
What do you mean by owner financing contract?
Contract for deed, land contract, installment sales contract, an actual bona fide sale, as opposed to, or as Scott does, the land trust or title holding trust, where you can avoid, any of these the equitable interest argument, all those things coming up in court. Obviously, you're already conveying that, but there's ways to rescind that as well. You don't have to have deed conveyance, so you don't have to. Be held as a security interest. I'm just curious. I know lease options were all the rage many years ago, and Claude Diamond made it really famous for a lot of people. But I don't understand them anymore, quite frankly, with all of the inherent issues.
I think in a land contract, you're giving too many rights to the tenant. So if they default on the payments, you almost are guaranteed that you're going to have to do a foreclosure. So if the worst case scenario of a lease option is that you're going to have to go through a foreclosure process, why not at least attempt the other way? Because like I said, most of the time you're protected, because the only time you're enforcing these things are when the tenant isn't paying. And if the tenant's not paying, they're paying usually because they have no money, which means they can't hire an attorney, which makes it easier for you to get this. Now, granted, it does sometimes just take one, or they go to a law school and they find someone, law students tend to do a lot more work than an actual attorney would.
They do.
You'll never hear another attorney say that, guys.
Yeah, that's true.
I'm telling you the truth.
Absolutely true.
I worked for the housing advocates when I was in law school. The research, you're excited, you're learning new things, and you're going to spend a whole bunch of time, looking into this and trying to figure out how this works. And you end up, spending a lot more time on it. But I don't know. And as far as the, owner financing, where you'll actually transfer title, again, I think it makes it even worse to try and take back. So I like the land contracts, or I like the lease options, because you have a chance of being able to take it back quicker if the tenant defaults.
So you're saying basically it's a lesser of evils, essentially, is kind of what it sounds like.
Yeah, I still prefer to use the trust, but I totally agree with you. I think that is probably the lesser of the evils, even as evil as that is.
Right.
So, but most of the people just don't. Even the people that sell the stuff really don't understand what the ramifications and the dangers and liabilities are of those contracts. So it kind of sneaks up on them. They're more aware of those risks and liabilities with contract for deeds and land contracts and seller financing and so on. They know that if they don't pay, they're going to have to foreclose. But when someone's in a lease option and all of a sudden the tenant claims equitable interest, they're going, "What the hell is that? What do they mean?" And they're totally lost, and they don't have the money to fight it either. And so, if the tenant brings up any kind of a decent argument or gets an attorney, they're screwed.
I have something to add. I think a lot of it depends on the tenant's mind frame. If they're in a buyer's mind frame, I think it's going to go smoother. But if you've got a tenant mind frame, they're not wanting to take responsibility for anything. They're blaming the owner for everything.
I agree with that for sure.
Yeah, that's true. When we look at people to put in our properties, I talk to the sellers. Ask me, well, who are you putting in here? Of course, that's a common question. And my answer is always, what I'm not going to put in here is renter mentality people.
Right.
And we have a process we go through. I really like to put people in my properties that have been homeowners before, or were just recently foreclosed or bankrupt. These people understand the emotional and financial responsibilities of homeownership. And just because someone was foreclosed or had to file bankruptcy, you got to listen to what their situation is, because they're not. You can't just classify them as deadbeat because they had to do that or something happened to them. You really need to look at their story, and I would highly recommend that in whatever transactions you do, really try to deal with people that are homeowner mentality people. And a lot of times, if I ever do open houses, I have 2 or 3 couples come at the same time, and I've literally had people fighting on the front yard of a house for the house because they were homeowner mentality people, and the ladies, it was 2 ladies, matter of fact, said, "No, I want this house." And she says, "No, you didn't, and I want this house." And now those are homeowner mentality people. Those are people that really want this house, right? So you got to really be careful. Everybody knows that, who you put in, but I look for that homeowner mentality.
Yeah, and I agree with you on that. And that's one of the reasons why we set our minimum price point at $300,000 and our minimum payment point at $2,000 a month, because from my perspective, what I want is 6-figure income households, and I want somebody that has been a homeowner previously, because they understand what the game is going in. There's some reason they don't qualify today, and so they're thankful and grateful for the opportunity to actually technically legally be able to own a home, and take the tax deductions and all those things. But when you're dealing with renters, or that's the thing I didn't like about the lease option deal. That's why we shifted away from it years ago. Is you do get that career renter mentality where the landlord is responsible for everything, and there's no personal investment in the house as it relates to taking care of it like a homeowner would, because they're just tenants, and I didn't want people stuck with that, if that makes sense. Right. So a lot of things, a lot to happen. Pardon me. On the lower end, when you're dealing with the first-time homebuyer crowd and all that, that's where I think you have a lot more of these type problems than you do. Lisa, what was the price point or payment of that property?
It was $98,000.
Yeah, there you go.
Right.
I mean,
and Vincent, I think you're dealing with the higher level homes, and you lean more towards that ownership, higher down payment thing. And I think the contract for deed is totally appropriate, and that's what I would use in those circumstances. I still think probably there is a place for the lease option deals on maybe the lower priced houses. I'm not saying like dirt cheap houses, but the median price and lower, that's where the lease option probably would work as well.
Yeah, I mean, properly structured, lease options they can be fantastic deals.
They can work really well if they're properly structured. But the key is, like you said, properly structured.
Yeah,
I'm totally. Vincent knows what I'm going to say here. I don't think you can properly structure a lease option. I don't think there's such a thing. I think that's a contradiction in terms.
Well, I'm almost inclined to agree with you. Back in the day, we turn back time a little bit. You could, but in light of all this recent case law and the way things have shifted, I would say I would have to lean more in exactly what you're saying. But yeah, there was a time they were fantastic. I did a ton of them my own on houses I got for myself. And I did one on a $2.5 million house that I personally moved into on a lease option, where the option fee, I gave her $10 for the option fee, and moved in for the first month's payment of $12,000. And it was a $2.5 million builder's model home that was completely decked out with all the decor and furniture and everything. And fortunately for me in that scenario, I did have a lease option. I didn't have a contract for deed, because when the bottom fell out, the property that was $2.5 million is now worth about $900,000. So that was a scenario where it was actually beneficial, for me anyway.
Well, Listen, I hate to be a party pooper. I have another obligation that I need to get to.
God, I appreciate it.
I really appreciate you asking me to be on this panel, and really like what you're doing. You know, we've all butted heads here and there every now and then, but it's really great when great minds can actually all get together, whether they agree or not. I think it's been very productive, and I think people will have learned a lot. And I certainly would be open to participating in more if you'd have me.
Hey, listen, I appreciate that.
Really want to thank you.
No, my pleasure.
All right, guys. Hey, thanks. I'm gonna take off now, but I'm sure everybody else will stick around and ask some questions of these knowledgeable guys. So,
all right,
appreciate y'all. Thanks, guys. Talk to you later.
Well, yep. Unless anybody has, I think we've answered. We have questions here.
Vince, I'm going to have to call in. I've got to disconnect from on here, so I'll call in on the phone line.
No worries. Jeremy's asking if you can't take more than 1.5 months rent up. From an investor standpoint, why would you do them? How can you make money doing them? What Scott was referencing is actually Arizona state law. It's Arizona state landlord-tenant law. Yep. I don't know that applies. I think it was kind of being used as a general.
Have you really, Vincent, seen that applied in other places?
I've never seen it applied any place else, and quite frankly,
I've not either. Now, I think it probably would in Arizona. You know, and apparently it may have in Utah as some type of precedent. But I've been doing subject to and lease option deals for quite a while. I've never seen that applied.
No, I've never seen it. And I have to be honest with you, when I first read it, it was about, I think, 2 years ago. And I was in a battle on a vacation rental that I was in, and I was having to go through and figure out exactly what the Arizona landlord-tenant law was, and I read that, and I'm like, "You've got to be kidding me!"
Yeah,
I just totally caught me off guard that was actually what the law was. I had to read it 3 or 4 times to make sure I understood it correctly, but that's the way they do it out here.
That's really kind of wild.
Yeah, I'm trying to think. There's something similar in New Jersey because we ran into that on one of the properties up there as well. That is a straight rental that I've got. And I can't remember what the exact number is.
Well, it sounds almost like Arizona has taken what Tennessee uses as their max for a security deposit and tried to apply it to an option fee, because that is the law in Tennessee, or it was at one time, and I think it still is that you can take no more than 1.5 times the rent for a security deposit.
Right. Yeah, I believe that. I think that's correct as well for New Jersey. Something similar to that. All right. Bruce is asking, in most of the courses, the assignment fee and option deposit are the same. How can the assignment count both as an assignment fee and an option fee to be used later as a down payment? How can it be both? And what is the proper way for the third-party investor to get paid? A way that allows for the buyer not to be required to put more money down when it comes time to close. Even as a contract for need, how do you structure your profit so that it will count for the buyer when he finally refinances?
Can you give me 1 second? I could probably answer that. You guys still there? Hello?
Is that Angelo?
Yes.
Okay, Angelo. Yeah, I can barely hear you, Angelo. I'm not sure if Vincent can hear you or not.
All right. Is that a little better?
A little better.
Yeah, I got you. I'm sorry. I muted out the coffee, and forgive me. Well, yeah, what I was saying was that the document that we just reviewed of Angelo's does not have, well, I guess there was a reference to it at one place, but you had an option fee of like $10 for the option, and then you had a separate assignment fee, which would be how the third-party investor would be making his money by assigning his right, title, and interest in that contract to the assignee and then tenant at that point. So,
correct. And you can't have both of those be the same thing.
Agreed. And I think it's where he was confused. You cannot have both of them be the same thing. They've got to be two different things entirely, because it's like trying to pay for two different things with the same money. You can't do that. And then you're asking, what's the proper way for a third-party investor to get paid on a lease option? I'll let Angelo and Bill address that one, and then I'll go into the contract for deed stuff and how we do it. So, Bill, what would you say is the appropriate way for an investor to get paid on a lease option?
On a lease option, if he's going to assign it, he gets paid an assignment fee.
Right.
And that's the only way really to do it.
Unless you're doing a sandwich.
Yeah, unless you're doing a sandwich lease option.
What I usually do so that it can count towards the purchase price is in the purchase agreement, we will usually give a concession equal to what the assignment fee was. And it's just coincidental that those numbers match.
Gotcha. And I tell you, you guys are lucky you haven't come across a wise guy yet that knows what the game is. Man, wow. I had a next door neighbor of mine who was owned about $30 million worth of commercial real estate, houses all over the United States and all the resort locations. Just, really sharp guy, very wealthy. And he ended up doing a deal with a real estate broker as his partner on a property in Alpharetta. And they got a guy in there, and they did one of these lease option deals with him. And they used, which they shouldn't have, and I try to tell them that up front, the Georgia Association of Realtors contract. And the guy got in and did exactly what I told you. He got in, he immediately stopped paying, and it took him 18 months to get him out.
Wow.
On a lease option deal. So this is a good listen. And we're talking about a seasoned investor who knows what he's doing, who's liquid multimillionaire guy. We're not talking about some one of these guys, new guys on Facebook. I'm talking about somebody who's almost 70 years old doing stuff. So anyway, all right. So then the next thing is how do you structure the contract for deed to profit so that it will count for the buyer when he finally refinances? There are a number of ways that you can do that. Probably the easiest way is to purchase the property and then resell it to him or assign it to him, depending on how you want to do it. But his down payment is technically a down payment that comes off of the purchase price, and it is credited against the principal balance so that he does get full credit for it at the time that he goes to refinance, which is what he's doing, is getting a refinance transaction and not a purchase money transaction at the time that he goes to get mortgage financing. On a lease option deal, and I will be the first one to admit I haven't done these in roughly 6 years. You have an option fee, and since they don't really apply the rent credits anymore, when he comes into purchase, it's a purchase money transaction. So unless there's seller concessions that are being allowed by the lender, he is going to have to come in with a down payment at that point. Angelo, is that still correct? We lose him? Okay, I think he fell off. At any rate, so that's my understanding anyway. So I don't know if hopefully that will help you.
Yeah, that Vincent too varies sometimes from lender to lender, but is essentially correct. I've found some lenders that will still allow the option fee if you can show that it was paid and have the paper trail. They'll still allow it to be applied to a down payment, but there are some lenders who will not. And I've actually found that to be the case for the last several years, not just recently, but I'd say even 10 years back, it would vary from lender to lender.
Yeah, I'm not aware of anybody that
So one thing I've told that I never do, and I teach my consulting students never to do, is never to try to guarantee that option fee is going to be applied to the down payment. It can be applied to the purchase price, but it may not be applied to the down payment. It depends on the lender.
Right. So applied to the purchase prices would then be a seller concession against principal balance, but it does not impact the down payment requirement. And
correct.
More than likely, depending on how they structure it, may or may not apply towards closing costs and prepaid items.
Right.
It probably is a straight principal balance reduction. All right, guys, unless anybody else has any other questions, I hope that was helpful for you. that is a clinic on why I don't do lease options, and you get to hear it from Scott, who lived it himself and was prosecuted for it. You get to hear it from Bill with the IRS. So, I mean, that's really the governing authority in the United States. There are ways to do them, but if you're going to do them, be very, very careful in doing these boilerplate contracts that you're getting from these courses for all the reasons that we just covered. In my opinion, there are better ways to do it, which is one of the reasons why we use a contract for deed. So, I mean, why risk a disguised sale when everybody knows what the intent is right from the very beginning, and just go ahead and sell the property at that point and put protections in place, ideally, so you can protect yourself from the judicial foreclosure process, which is what we do. And in my opinion, that's a better way to do it. And I've never, I'll knock on wood as I say this, in 7 years, we've never been forced to take any buyer through the judicial foreclosure process with any document that we've used, period. I've only made it into court one time. It wasn't me. It was because I wasn't even technically party to the contract at that point. I had signed it. But we've had one landlord make it into court, and because of the contracts that we used, and this was actually on a lease option, not on a contract for deed. This is back in 2008, I believe. And because of the language that we had in the contracts, as I indicated earlier, where they're waiving rights to jury trial, waiving rights to affirmative defenses, waiving equitable interest, all that stuff, we were able to get the landlord in and out, and the dispossessory action issued, without any further delay. And the judge actually said to the tenant that he agreed with him that the contract was extremely egregious in favor of the landlord, which it was, but the fact remained that he had signed it and agreed to it. He had an opportunity to have it reviewed by an attorney before doing so. And he swung the gavel. Yeah, swung the gavel, and that was it. So anyway, I hope you guys are taking this stuff seriously. This is a serious business. This is not a hobby. With Dodd-Frank, as Bill will tell you, it's not playtime anymore, guys. It's just not. You got to be careful with what you're doing out there. And if they can chain these things together on a lease option to, define equitable interest in a disguised sale, they're only one step away from bringing Dodd-Frank in, and then you're going to end up in a scenario where you can potentially have a seller lose his house because he did a deal with you. I don't think that's what anybody wants to do. So, Bill, I want to thank you very much for your time today. I appreciate that. And I want to thank you for that post that I found this morning that substantiated everything that I was trying to say very succinctly. Appreciate that very much. And other than that, guys, listen, thanks very much and have a great day.
Thank you for listening to the Virtual Real Estate Investor Podcast with Vincent Polisi. If you found any value in this podcast, please use our Give to Get method and take a moment to give us a 5-star rating in iTunes and your favorite podcast service so we can keep giving you excellent episodes of real content you can use to profit today.